Boston, can you hear me?
Yeah.
Okay, Caitlin Boston, you just hold on a second here. You know what we need from you, Caitlin, is what's that? We need a good address for you, a good mailing address.
You can have my mom's address.
Okay, hang on just a second. Let's see how long this warrant's been out for you. Caitlin, we can't have you just blowing off court. You got to show up when we want you to show up, you know.
Okay.
The case is January, came from June 2021. So the case is over 2 years old. And bench warrant quash was set for May 25th of this year, and you weren't present. So we're just having a heck of a time getting here.
I know.
Well, are you living in Forks or Port Angeles?
In Port Angeles.
Okay. And you know how to do Zoom yet? Do you have a telephone or tablet you can do Zoom on?
I don't have a phone right now.
Okay, so what you're really telling me is I don't have a good reason to quash the bench warrant. I'm probably going to keep bail right where it is, unless I know I can get you to court. Right? If you don't have a phone, you can't.
My mom.
What?
Well, my mom lives in Forks, and she is. I think she's willing to help get me to court.
Yeah, well, see, we got to get past the I think, and we got to get to the I do. So we're kind of past the. You know what I'm gonna do, Caitlin, is if Melissa, if Clown Public Defenders is off the case, we want to put them back on.
Okay.
And so I got a problem here, Caitlin, because we don't actually have court on the 3rd. We got 4th of July is on Tuesday, so we're not coming back till the 10th. And right now I'm going to keep bail right where it is. I can't change bail. I know. Please. I don't want to do that. I don't want to do that to you, but we've already been through this 2 or 3 times. You call the court.
My mom, I promise that my mother will help me get to court.
Well, your mom needs to get in here and talk to the prosecutor about that, because I'm not going to do anything different until she actually talks to the prosecutor. Right now, we're going to keep bail right where it is, and we're going to come back to court on July 10th. And you're going to have your attorney, Mr. Kressel, and we'll let Mr. Kressel know that he's been appointed to represent you. And if Mr. Kressel and Mr. Fleck can work out a different arrangement, we can always change bail after Mr. Kressel and Mr. Fleck have had a chance to talk. But right now, what I'm looking at is we've been through this at least twice, and so we're not going to change bail. We're going to keep bail right where it is, and we'll see you back here in court. If you do get bailed out, we're going to need to see you here in court at 1:30 on July 10th. July 10th is a Monday, so we'll see you July 10th at 1:30. Okay.
Okay.
See you then. Thank you, Jail.
Thank you, Judge.
All right, good morning. Listen, I set bail on you the other day because you weren't here and I wasn't sure what your situation was. It sounds like you turned yourself into jail after talking to your dad. Is that what happened?
Yeah.
Okay. So I'm a little bit concerned about you because I don't really know what your living situation is. And I'm concerned about you using when you're out. So here's what we're going to do. We're going to keep the bail right where it is right now. Okay. You'd have to post bail to get out. And I'm pretty sure I appointed Clown Public Defenders to represent you. So, Doug Kressel is going to be your attorney. We're going to let Mr. Kressel know that you're in custody. Now I got $2,500 cash on both cause numbers. Do you think your dad's going to post that bail or not?
Yeah.
Okay. Well, we're going to bring you back to court on July 10th. We're not going to bring you back next week. We're going to bring you back on July 10th at 1:30 in the afternoon, July 10th at 1:30. Clown Public Defenders represent you. You're going to have to post $5,000 cash to get out. You can have no new criminal violations. You're going to have to abide by all no contact orders of the court. So, for example, the private property that you were on that day, you can't go back to that address. Anyway, We will see you July 10th at 1:30, okay?
All right.
Okay.
Not happy. Hi, who are you?
Pardon?
Who are you?
John Dahlgren?
Well, that's an
You're here for the ticket.
Yes.
I'm not gonna wear my robe because Dahlgren won't care if I don't wear a robe.
Come on up.
All right.
That's a 3A02939335. How you doing, Dahlgren?
Good, good.
You staying honest?
Oh, yes.
I figured.
That's why I got the seatbelt ticket, because he asked me if I was wearing my seatbelt. I says, no. I says, okay, well, I'm gonna give you a ticket. I was just honest. So.
Well, why weren't you wearing a seatbelt?
Oh, I'm in and out all the time. You know,
I do. But why? What are you not still working, are you? Is that why you're in and out?
I start late and quit early.
No, but I mean, are you cruising timber? What are you doing when you get in? You're cruising timber?
No, not cruising timber. Side rod, just making sure the operations.
Yeah, oh, I see. So
Go.
you're actually,
I'm
you're actually still logging.
well, yeah, I'm not out there setting trophies.
No.
I can't do that. You know that. But
Yeah, I do know that.
but,
We're old.
oh yes.
Well,
But-
Dahlgren, you criminal, can I borrow your pen? We're gonna let this criminal go.
All right.
You okay with me letting you go?
Oh, certainly.
Just don't get in an argument with that guy and have him bring that up. Dahlgren, he's been around forever.
Oh,
Dahlgren's been
yeah.
logging since before Noah. All right, you're gonna get a copy of that dismissal, okay?
Okay.
Don't make me stupid.
No. I won't. Not. I won't.
I know you won't.
I know I'm all good.
So he's in custody on the Superior Court matter.
Right.
But what I'm asking the court is just bump this to July 10th so I can have a better assessment of what we're doing with this current case. At the very least, there's some witnesses listed that are probably going to be a bit of a challenge to contact, and that my investigator is trying to do some follow-up. But those are all issues I need to discuss with Mr. Hillstrom. So I would ask us to put this over to July 10th for status.
Mr. Murphy, that sounds very reasonable. Are you okay with that?
It's fine with me, Your Honor. I would like to address conditions of release, though.
Oh, yes, go ahead.
So originally bail was 10,000 cash or $100,000 bond, and then that was set May 25th, and then on June 1st, the court ordered the bail to $2,500 cash or $25,000 bond. I think based on Mr. Hillstrom now being in custody on assault 2 and assault in violation of a court order, domestic violence, being the same person, I would ask that bail be increased back to the 10,000 cash for $100,000 bond.
What day, what was the date of the new offense? Do we
June
know?
9th. June 9th.
So that's happened since we found probable cause on this one,
That's
is what
correct.
you're saying.
Yes.
Mr. Kressel, he's making a good argument.
And unfortunately, it's new information. I was out of the office last week. I did see the probable cause statement. It appears to be involving the same person.
Right.
But other than that, I can't really address, and I would just reserve.
Well, Mr. Hillstrom, I don't have the probable cause for the new charge, but part of why I lowered the bail was on the strength that you weren't going to have a new offense. Given that there's reason to believe you have violated the court's previous order, bail on this matter on the 679800023 is now $10,000 cash, which is where we started. Let me grab my water. So $10,000 cash on that now. He's not getting out until they post another 7,500 on this one.
So, Mr. Hillstrom, this case is being set over. Next Monday is technically a holiday, and there's no court. So we're putting it over 2 weeks. You also have court on Friday. I'll be down to see you to discuss these issues, but you have court and Superior Court on Friday as well.
Okay, county jail. Is that it for the county jail, Melissa?
I believe it is.
Okay, thank you. Now, we got Kettle, yeah, there's Kettle. Is that Kettle?
Yeah, Mr. Kettle's gonna be a change of plea. We got 3 case numbers. He's been in for a chunk of time. I just need to find my file. Here we go.
That's not food. No, never mind.
So he's gonna be entering a guilty plea. I'm not sure where you want to start. We got 67960023, which is a violation of the no contact order. 6627-0022, which is a DUI from a period of time ago. This was the first one in the series. And then the most recent was 665-00023, which was an assault charge. He's been in custody for a good chunk of time. Some of the issues is that he's in the county jail, and logistically it's hard to coordinate things, but I think he's got a couple of months under his belt.
Okay, before I start filling out JNS, are we doing a plea on the alcohol offense, the DUI?
We can start with that one.
Okay, I just need to make sure I got the right JNS. We got 2 JNSs.
We got 2 JNSs. One's a DUI for over a 0.15, and the other 2, we got an assault 4 DV and a violation of no contact order DV. The recommendation total, if I'm remembering the state's recommendation, I think it was 30 days total. And he's got like probably a good couple months under his belt. But I will hand up the plea of guilty on 66270022, which is the DUI over a 0.15. Recommendations: mandatory minimum 2 days, 5 years probation, all the standard DUI conditions, drug and alcohol assessment, apply with any treatment, DUI victims panel. I believe, if I'm remembering correctly, he had an assessment, but I know he's been having some challenges being in the county jail. And there was an assessment, and then he had some medical issues. That assessment has since changed. But he's gonna have to get up to speed and probably get that updated when he gets back out, especially with everything going on.
And Mr. Kettle, I'm jumping ahead a little bit. You intend to stay here in Forks, maybe live with your family, don't you?
Yes, Your Honor.
Okay.
And Your Honor, yeah, that kind of, the other 2 cases, I believe one involved his mother, if I recall.
Yeah, that was no contact.
And I think at some point, I know the no contact order was lifted because she was providing transportation everywhere.
Right.
And then there was a civil no contact order that was entered, but I think that one was also lifted, but I'm not sure on that.
I'm not sure. I did it on a Thursday or Friday, and then we had a violation. We haven't gotten to that one. So.
No, we haven't gotten to that one yet, but I think if I'm remembering what my client has told me correctly, it was set for a civil hearing, and either she didn't show up or it was stricken. So, but I'll rely on the court's information because I don't.
Right. All right. So on the 6627-22, Mr. Kettle, I'm looking at a statement of defendant on plea of guilty for DUI over a 1.5. Says your age 30. You got through the 12th grade. I'm assuming that's here at Forks High School. And I'm sure it was, the maximum is 364 days in jail, $5,000 fine. When you plead guilty, you're giving up your right to a trial by a judge or jury, giving up your right to remain silent, giving up your right to hear and question the state's witnesses, giving up the right to present your own defense. You're giving up the presumption of innocence to make and prove the charge beyond a reasonable doubt, giving up your right to appeal a finding of guilt. I'm not bound by anyone's recommendation. You understand all those rights, don't you, Mr. Kettle?
Yes, Your Honor.
Says here, your statement is on December 16th in Clallam County, I drove a motor vehicle with a BAC of 257 and was too impaired to drive. I'm assuming that's your statement. You went over this with your attorney, didn't you?
Yes, Your Honor.
And I remember there was a factual basis. I just reviewed that, but I happen to remember this. So I'm finding there's a factual basis for the plea. and that it's knowingly and voluntarily made. Now, how come Mr. Kressel and Mr. Murphy, we got a recommendation of 2 days?
The mandatory minimum is 48 hours for a DUI over 1.5.
Correct, and this was his first DUI. He doesn't have much history.
Right.
This is kind of a classic case of someone who's had some issues for a period of time, but been able to stay mostly out of the court system. But in the last year or two, it's kind of snowballed. But he had also, after this incident, basically a near-death experience, was in Harborview. And so let's just say Mr. Kettle has had some eye-opening experiences in the last year and a lot of time to reflect. He does need treatment, that's without a doubt. But we're probably going to need an updated assessment to see exactly what level of treatment, because he had an assessment done right after the DUI, then all this stuff happened. It was a matter, I don't know if he still needs residential treatments or if he's just been sober long enough, he needs IOP, but he's definitely going to need treatment supervision. It's just, I don't know what level.
Right. So, Mr. Murphy, I don't know if you have an emergency response fee in mind. Mr. Kettle he's been in and out of jail.
There's on here 133.16, if I'm reading the handwriting correctly.
Is that what that is? 133.16, Mr. Murphy?
If it's written by me and it's badly done, yes, I think it's 133.16.
It looks like 133. It could be 153, but it looks like 133.
133.63?
What, 133.16?
16. Okay, so
Yes, it's 133.16. I can confirm that.
I'm only going to order the emergency response fund because Mr. Kettle, when's the last time you actually worked, Mr. Kettle? Do you recall?
It's probably been like 8-9 months.
Right, and he had a serious hospitalization. I want him in treatment. I don't want him spending money on anything else. So your total legal financials is going to be the 133.16 for the emergency response fund. The biggest things are you can't drive a motor vehicle without a valid license or while impaired under drugs or alcohol of any kind. You can have no new criminal law violations, have to comply with the rules and regulations of the Department of Licensing, including an interlock. This is the page I messed up last time. Probation for 60 months. Now, go ahead.
And Your Honor, I believe, because I have a couple different recommendation sheets. One was from the DUI and then one was from Global. I think the concern on all of these cases, aside from the addiction issues, there may be co-occurring issues.
Right.
So I think the state's requesting, if I'm reading the offer sheet correctly, both the mental health assessment and the drug and alcohol evaluation.
That's right.
Okay, so I'm checking off that he needs to provide a new and updated substance use disorder evaluation, but also a mental health evaluation. I need him to start that within 30 days of the judgment and complete both of those within 180 days. I don't know what our current assessment availability is in Forks, but it's got to be done sooner rather than later.
If he's in Forks, we should be able to do co-occurring assessments.
Right. So, Mr. Kettle, when you're on probation, if Ms. O'Brien tells me that you're not calling her or that you're not getting an assessment or that you're not showing up for meetings, I'm just going to put you back in jail.
All right, Your Honor.
Well, I know, and I hate doing it. I don't take pleasure in that. I just got to make sure you don't hurt yourself goofing around. And all of that is going to be per treatment / probation. Whatever Ms. O'Brien tells you got to do, you got to do. Can't use alcoholic beverages or non-prescribed drugs at all. Today is 6/26/23. You can look this over, Mr. Kressel. I tried to check every possible box to make sure we don't miss anything. Only County LFO with the 133.
Yeah, and that's much appreciated. So, Mr. Kettle, the judge cut you a huge break financially, basically imposing just the 133.16.
Okay.
But you have both, you need both the mental health and the drug and alcohol assessment, because the concern is there may be a co-occurring issue, which both issues need to be addressed. And that can be done through WEOS. And then presumably a DUI victims panel, and you're going to be under supervision of court's probation on the DUI for up to 5 years, but you'll only be on active probation while you're in treatment. But if you get new cases, the court's going to have a whole bunch of jail time to play with on all three of these cases. So you want to make sure you follow through.
And I can't drive unless I have an interlock, right?
Correct. And that's going to be between you and DOL. But yes, standard conditions for DOL is going to be an interlock. It's going to require SR22, relicensing fees, and there's a whole bunch of things you're going to need to do to get your license back. And then I'm just going to hand up these other two forms. You got 665-00023 and 6796-0023. One count of assault 4DV, one count of violation of a protection order. And hopefully the math is correct, but the intent was all three of these added together is 30 days, and he's probably got a couple of months under his belt.
Okay, well, again, Mr. Kettle, you already know this. You're giving up your right to a trial by a judge or jury, giving up the right to present a defense. Maximum punishment for both is 364 days in jail, $5,000 fine. I'm not bound by any agreement. If I thought you needed to do a year in jail on both of these, I'd do it. And trust me, if I thought you needed that, I would. Do you understand all those rights?
Yes, I understand, Your Honor.
Okay. So on the 679623, it says on May 13th, 23, I violated the terms of a no contact anti-harassment or protection order with a household member, and I had just signed that order like 2 days before or something.
Yeah, and if I recall, this is the one, I don't want to be mixing up the case. I think he was asleep on the
porch or something.
Porch, yeah. But yeah, but as far as the status of that, I don't know the status, if that was still in effect, or if the mothers didn't come to the hearing, or, oh, here we go.
What's it say? What'd she tell you?
No show, it was dismissed and closed. Okay, so it
There you go.
appears the civil no contact order is no longer in effect.
Okay.
So I will defer to the mother's wishes. I know she was helpful with
Yeah.
Mr. Kettle in the past, but
Right.
if there's not a no contact order currently. in
Well, the
effect.
problem we had is when, and you know this, Mr. Kettle, if you start using, you scare your family.
Oh, I know.
So hang on. I know. We all know now.
Sorry.
Everybody knows. That's all right. So anyway, on that one, violated the order on May 13th. And then on this one, January 7th, this is the 6650, January 7th, in Collin County, I intentionally touched or struck another without their consent and not in self-defense, household member. I'm going to find that both pleas were knowingly and voluntarily made. Now, let me just, and that there's a factual basis. Let me do the 6650 is the assault 4th degree. 4th degree. And the 6796 is the VNCO. Okay, and they are both domestic violence because they are household or family members. So on the
Yeah, and I explained to him that this, I believe it's a moot point because he may have, I thought I saw something in there that suspended his firearm rights, but if not, both the assault and the violation of no contact order would suspend his firearm rights until reinstated by the court.
right. So the 6796 is the 364, 352, So let me see, that is 8 and that's 12, and then 5 is 7. How many days does that add up to in your mind, Mr. Kressel?
I was getting 29, but I could be off. I was getting 12, 15, and 2. I don't know if the court wants to
Oh,
do
12, 15, and 2, that's right. I
That
see
would be
what you mean.
29, or the court wants to do 12, 15, and 3. Either way, he's got a couple months under his belt, but
Yeah, so, oh, there we go. Notice of ineligibility of a firearm, might as well do those here pretty quick. Okay, so I have a total of 15 days on one and 12 on the other. Total jail time. And we think he has a total of 27 days here. And we think he has credit for 27?
yeah, the latest violation, which he's in custody for, was on May 13th. So it's already June 26th. So he's probably has about 6 weeks on that. And then on the original DUI, that I think he was in for about a week or so. But yeah, it's expected he's got the credit.
Well, and Mr. Murphy, I don't have a good reason to impose any legal financials on Mr. Kettle. He's, Mr. Kettle, how's your mental health lately after your last 6 months? Are you functioning? Well, how are you doing?
Yeah, I'm doing better.
Can you
Your
think
Honor.
you can get a job? You think you can get a job anytime soon?
Yeah, that was my plan.
Okay, what we're gonna do then on this one is he can pay court costs of $200, and then a conviction fee of $43, so a total of $243 on that one.
And Your Honor, I would request
$244.
the $100 domestic violence, $15 domestic violence assessment.
Okay, let me get that right box. Domestic violence assessment, $100, so the total is $343 and no cents. It's the same thing though. Now, on this one, Mr. Murphy, Mr. Kressel, do we want him on a probation on this one too or not?
Yes.
Okay, so we're gonna put probation for 24 months.
And Your Honor, for simplicity, it'd probably be best to keep the conditions the same as far as requirements of drug and alcohol and
yes.
It's not entirely clear if it's co-occurring, but it's suspected to be. And so he should be able to get the services he needs here in Forks.
So attend meetings per treatment, same thing I said on the other, per treatment, probation, can't use alcohol or drugs, obtain substance use evaluation, mental health evaluation. Any questions that Ms. O'Brien has, if I happen to miss a box anywhere, I'm sure we'll hear that, because you are under supervision there, young man. We know each other now. We have some history, and I will remember you, I guarantee you. And if I see you in here because you're having fights at home or because you're using, I'm just gonna put you in jail for 6 months, no questions asked. So
I understand.
I know you do. I don't want to see you back here. I want to hear about you doing well. I want your mom to tell me you're doing well.
So Mr. Kettle, a couple things. Yeah, when you get out, you need to have an assessment scheduled for both drug and alcohol and mental health. And West End should be able to do that if you're in PA. There's a number of agencies that can help out with that. But for the DUI, you're also going to drug and alcohol, or excuse me, a DUI victims panel. But one of the first calls you should make is to Lorraine O'Brien. She's going to be your probation officer. She'll kind of walk you through that. The court's not imposing a separate no contact order, and it looks like the one that was in place is expired. So whether or not you can see your mom's between you and your mom, but your first step is getting in the treatment.
Sounds good.
And Your Honor,
How you
did the
doing?
court,
Yes,
did the
yes.
court receive the submission of a biological sample?
Oh, I don't think I checked that box. We do need to get a biological sample. I need to find that where that box is on that. It's somewhere on those.
What is
And Mr.
that?
Kettle, that just means a DNA swab, just a little Q-tip on the cheek. It's no big deal. But they'll do that
Alright.
before you're released.
And Your Honor, I don't know if the form's been updated, but based on a recent, I don't know if it was the Washington State Supreme Court or the Court of Appeals, but that, because he's indigent, that biological sample cannot be, or the fee cannot be imposed.
Yeah, I'm looking for ways to not impose fees on him at all. I'm looking for that box. Well, there's the DNA fee. I found that box, but I don't care about that. I care about the condition. Consumer awareness. It isn't page 1? I'm doing his firearm and eligibility while you're looking for that.
Yeah, if not, it can always be written in.
We can always write it in too.
And I also, I emailed Mr. Downing and Ms. Freeman a minute order regarding the biological sample.
Well, it's okay. I checked a box, which I think says that, and I put 2 cause numbers on one notice. So declaration, here's the notice of ineligibility to possess firearms. I don't know if
I think Mr. Murphy's concern is sometimes the jail without a specific order,
oh,
even though it might be in the JNS.
right.
So if Mr. Murphy sent an order, I would have no problem agreeing to it.
Are you gonna send an order, Mr. Murphy? You want me to? Okay. Right, well,
Fine, yeah, it should be right there.
mine aren't either, obviously. I'm doing, okay, I'm doing a minute order for the biological sample. Now, before I forget, I did an ineligibility of possession of firearms. Do I need, look at that. There's an order for submission of biological samples. Do I need a declaration of non-surrender for a firearm?
So that's connected with the order to surrender and prohibit weapons, and that's Mr. Kettle to enter if he has no weapons to surrender.
In
I
my
have no
understanding,
weapons.
he has,
I figured.
I yeah, my understanding, he has no weapons, so he would.
I don't know if you want to fill that out for him to sign or not. I'm working on the minute order requiring submission of biological sample, which somebody filled out.
Comes to the jail or?
Yes. And then you can fit signatures.
Okay.
Yeah, that's
Okay,
one. The
so-
non-surrender is something he signs.
Mhm.
Okay, and I think this will cover it for a swab. I don't know if Mark typed it in real quick or if it comes that way.
I believe Mr. Murphy did that.
Oh, Murphy sent
I
it.
have a feeling Mr. Murphy's done this a few times.
Has Mr. Murphy done this a few times?
Maybe, just a hunch.
Yeah, they're gonna swab you, Kettle, because there was a domestic violence and that's just part of state record keeping. And the jail's gonna make sure and do that, we think. So does Mr. Kettle get out today?
It's expected he would. So he's going, Mr. Kettle, one of the first phone calls you need to make is to Miss O'Brien. And then also.
The sheriff's office took my cell phone. Do I go back to them to get it?
Any property taken, that's gonna be between, it depends where it's at. If it's in the jail, in your personal belongings, you'll get that when it was released, or excuse me, when they took you into custody. If it was booked as potential evidence, that may take an extra couple weeks, depending where it is. But if it was taken by the jail as part of your personal property, that you should get when you're released from the jail.
Okay, so that's it for the county jail. Kettle?
We got 2 for Forks.
Well, I know, we're going to go to the Forks jail here in a second. So I think that was it, county. I forgot that you had Kettle there. Or is that it for Kettle? Did we get Kettle all wrapped up?
I believe so. I'm not sure who's.
Now, Mr. Kettle, first thing you do
All right,
is get
see
in
ya.
contact with, get in contact with Ms. O'Brien and make sure you go get your assessment and we'll be okay. You and I'll be okay.
All right, I'll call in a bit. Thank you, Your Honor.
Thank you.
Thank you, Your Honor.